Good morning, everyone, or good afternoon if you're joining us from outside of the Caribbean region. My name is Shan Greer, and I am the CEO, newly appointed, of the BVI International Arbitration Center. We are excited about this first webinar in our Journey to BVI Arbitration Week series. This roadshow, which will include events that will take place throughout this 2023 and lead up to our Arbitration Week in March 2024, is part of our commitment to capacity building and promoting the BVI and our center as a good place to resolve your disputes. Now, today we're going to be talking about a not so sexy arbitration topic of confidentiality. And I know that it is one of the benefits frequently touted in the name of arbitration, so much so that I think very often people assume that it is as of right. Those in the know that that's not always the case, and that the issue is somewhat more nuanced. And to help us navigate through this process, I am here with Arabella Diorio, who will be moderating this session. Now, Arabella is a respected attorney and arbitrator based in British Virgin Islands with me, my new home, her home for some time now. She started her career at the English Chancery Bar, worked for Linklaters in London, decided to join us in our Sea and Sands location. I'm working in Applebee's in Bermuda, and now with her own firm, Aegon Litigation in Tortola. Arabella handles a wide range of high-value, complex international disputes and regularly advises on commercial disputes. She's also an arbitrator on our panel, and so well placed to take us through this topic. Arabella?
Thank you, Sean. Very kind words. We've got such a very distinguished panel today that they hardly need any introduction, but my instructions say introduce panel. So that is what I'm going to do, although I'm going to do that very briefly. And my apologies to them all in advance. That's in no way to downplay their extraordinary achievements. Sean's pretty much introduced herself. She's the brand new CEO of our International Arbitration Center here. Her career in private practice saw her act as arbitrator, mediator, adjudicator, and counsel on many disputes. But it's the development of arbitration in the Caribbean which really gets her eyes shining. So we're absolutely delighted to have her here. Bringing the US perspective to what we're going to discuss today is Nancy Thevenin. She's an international arbitrator and mediator, and she's based in New York. And she is the founder and principal of Thevenin Arbitration and ADR. She's had an astounding career so far, combining private practice with academia, and she has lectured at some of the US's greatest law schools, as well as handling disputes for multinational companies and governments over a wide range of industries. I'm next going to turn to Shai Wade. He is a partner and the head of international arbitration at Reynolds Porter Chamberlain in London. He has a huge international arbitration practice with a focus on oil and gas and the energy sectors, as well as construction, mining, and IT. Somehow, he has also found the time to write the leading textbook on LCIA arbitration. And last but not least, we are privileged to have two speakers on the panel from Debevoise in London. We have International Counsel Dr. Conway Blake and Maxim Ozachi, whose surname I have no doubt just horribly mutilated. Conway has a very wide practice, focusing in particular on investor-state arbitration and public international disputes. What really caught my eye when I was looking at his online bio, though, is his pro bono work. And he has represented clients before the European Court of Human Rights, the Inter-American Commission on Human Rights, and the African Commission on Human and People's Rights. Maxim has considerable experience in international arbitration. He focuses on large PPP and concession projects, as well as oil and gas, mining, construction, and pharmaceuticals. And his cases often involve parties from the CIS and Eastern Europe, and he has a thriving commercial disputes practice outside arbitration as well. As Sean has said, our topic today is not necessarily sexy, or at least not sexy at first blush, but it's a slow developer, I think. I suspect many people would just roll their eyes and say, oh yes, well, we all know arbitrations are confidential, so what can there possibly be to talk about? But that's not necessarily the case. And that's really what we're going to be exploring today. So we're going to take a closer look at 4 topics. And the first one is really a question of whether or not confidentiality actually matters to the market. Do they care? I'm going to turn to Conway first of all. Does confidentiality matter, or these days are things like speed and cost effectiveness actually what drives the market? Are those bigger attractions than confidentiality?
Thanks, Arabella. And I think the speakers are absolutely right to say that confidentiality is an aspect of arbitration that is always taken as a given. And actually, what we see is it is one of the main drivers for international parties to engage in international arbitration. Arabella, you mentioned speed and costs. One of the things that we know, having feedback from the users of arbitration, is increasingly that speed is no longer associated with arbitration. And the exponential rising costs is also something that is a real concern for stakeholders. And what we're finding is that it is really confidentiality that remains one of the key drivers for business parties to keep using international arbitration. And that is borne out from the surveys that have been done over the years of the users of arbitration, in particular from Queen Mary, who we know has been doing a number of surveys over the last decade. And what is very interesting looking at that surveys, since 2006 all the way to 2021, users have consistently said that arbitration, one of the key reasons they engage in arbitration is for confidentiality. So just by way of example, in 2006, 9 out of 10 users stated that they would avoid transnational litigation because of concerns about a disclosure in public, and that arbitration was therefore a key advantage for them. And as recent as 2001, people were really concerned about confidentiality as a reason why they'd wanted to move away from online hearings and wanted to get back in person. So it has, over the years, been cited as one of the main drivers for decision makers in international disputes.
Thank you. And Shai, does what Conway has just said resonate in the institutional arena? Are there different trends developing there? Shai, you're on mute, I think.
Hello, now not on mute. And thank you very much for organizing this great webinar and for inviting me to participate. I think it's a sexy topic because nobody knows what's hidden underneath, if nothing else. Where do I start? On the issue of confidentiality, one leading textbook
Written by you.
says that confidentiality is often touted as one of the key advantages of arbitration. And I think that's true. When we talk to clients, we tell them your proceedings are going to be confidential. But what we often gloss over is that the extent of any confidentiality and indeed whether it's an advantage for a particular client or a particular industry is correct. That depends on the parties' perspectives, obviously, but also on where they agree to arbitrate and under what rules. So in many more instances than you would believe, there is diversity between both seats and arbitration rules as to whether there is confidentiality attached to your proceedings. Now, taking just the point with regard to arbitration rules, there is, in an industry where harmonization is de rigueur, it's the name of the game, there is perhaps less harmonization when it comes to the issue of confidentiality in arbitral rules. So taking the leading international arbitration rules as my first example, the BVI IAC rules in their preamble take the position that unless otherwise agreed by the parties, the award, but also all other matters relating to the arbitration proceedings, including its existence, for example, which is quite stark, shall at all times be treated as confidential. Many practitioners would take the view, without examining the rules or the law of their seat, that the existence of an arbitration isn't confidential. In fact, you are often required, if you're a corporate entity, to report the existence of a dispute, and therefore there might be a slight conflict there. But that is one approach which isn't unusual in arbitration. A less prominent set of rules written by the LCIA in 2020, Article 30, confirms that all materials created for the purpose of the arbitration and any documents produced in the course of the arbitration shall be kept confidential. The SIAC takes a similar approach. The ICC rules, on the other hand, take the opposite approach. ICC in Article 22.3 says that the presumption is that the confidentiality will only apply if one of the parties requests it. And in a strikeout from the norm, although there are one or two institutions that are following, the ICC also decided in 2019 to publish all arbitral awards issued under its rules with anonymization applied, unless the parties specifically request that it should not be published. Publication is, of course, also has always been the rule, or for many years at least, almost as long as I've been practicing in ICSID arbitration. Awards are published there. Now, to skip over some other institutional rules, is there a trend? I think that at the moment it's difficult to predict a trend or see one clearly emerging. I assumed when I started looking into this question for today that there would be a trend towards transparency, but I'm afraid there isn't one. There are some institutions, there's a body of institutions, by body I mean the ICC and plus one or two others, that have moved towards transparency, but the vast majority at the moment follow the BVI rules and have maintained confidentiality as the default.
Thank you very much for that, Shai. Nancy, can I come to you on these issues? Is the American perspective any different to what we've heard so far? Do you see any trends developing in your jurisdiction?
Thank you for the question. And thank you so much to the BVIAC for inviting me, and specifically Sean. I'm delighted to be here. I agree with what Conway and Shay have said a lot, right? That from our perspective, confidentiality is a concern, but it is not the main concern of parties. At least that's what we've seen. So if you look at the United States, just to back up, we all understand that our arbitration is private. It is not necessarily confidential. The two words don't mean the same thing. It is private, but in the US, it is not necessarily confidential. So what are you looking at? Whether to determine if your arbitration is going to be confidential. Is it in the parties' agreement? Do you have a confidentiality in your agreement? Is it part of the institutional rules? Is it the law of the seat? If you look at the US, we have a federal system and we have a state system. You look at the federal law, the Federal Arbitration Act, there is no requirement that the arbitration be confidential. Now you look at the different states, right? The different states have different arbitration laws. Delaware is unusual in that its arbitration law provides that arbitration is confidential. However, the states that have adopted the revised Uniform Arbitration Act or the model law, the UNCITRAL model law, do not have an obligation of confidentiality. And that takes me to the UNCITRAL. If you look at UNCITRAL, its rules and its model law does not have a requirement for confidentiality. So at least in the US, those states that have adopted it haven't necessarily included a provision of confidentiality. So you'll look at the US and think, goodness, they must not care about that. Not at all. Let's look at the institutional rules. At least the institutions that are very active in the US, Shay already covered the ICC, no requirement. ICDR established in 2021 that it does. CPR administered rule does, and JAMS does in their international rules, but not their domestic rules. So if you look at this picture, my take on it is that it is a concern in the US. It is not the concern. We leave it up to the parties to determine if they want confidentiality and to what extent. And I'll stop here. Thank you.
Thank you. So, Sean, a concern, but not the concern, and no developing trend. Anything different in the Caribbean?
Yeah, no, I think I would, from a Caribbean perspective, I think it's somewhat consistent with the American perspective, in that cost has always been the most important thing that parties look for, or just going to be the decider. And I think confidentiality tends to be an after the fact issue, which is, oh no, we have confidential information, how are we going to deal with this? But I think that trend is changing in the region for several reasons. First, over the past 20 years, we've seen phenomenal growth with a lot of foreign direct investment and a lot of very large infrastructure projects. By way of example, Barbados just received funding for its renewable energy transition, which is in the hundreds of millions of dollars. But more often than not, the persons who are going to be carrying on these works are going to come from abroad. And when you have this sort of interaction, confidentiality is going to start mattering. I think a good saying is, you don't know what you have till it's gone. And I think in the last 3 years, we've seen the impact of what happens if you don't have confidentiality. I'm going to do the nerdy lawyer thing and refer to a few cases just to illustrate the point. I think the first one is OAS versus NIMCO, which is a Trinidad case. It was a Brazilian contractor who was engaged by a statutory body in Trinidad to do this very large highway project. It went to arbitration. LCIA, 3 arbitrators gave a decision. The government, in favor of the Brazilian company, the government took it to the High Court. The judge did a detailed analysis, and under their law decided that he was going to set aside the award on the basis that no decision maker could reasonably come to that decision. That decision was then, because it was a controversial project, the subject of a lot of debate, both in the arbitration community and in the news media locally and regionally. It was even featured on GAR. And when I read the decision, I was thinking about this Brazilian contractor and whether they had given any thought to what would happen if, whether they gave thought to this particular scenario of all of this information being out there and people questioning, what they did, why they did, and how they did it. And, at first I should say, okay, well, that's more an investor problem. And in fact, it isn't. And that leads me to my second example, which is the case of True Blue True Blue Development, which is a company that invested in Grenada under their Citizenship by Investment program. COVID came, things did not go awry. The Grenadian government took action, investor didn't like it. His conversations with them did not go particularly well. Things went bad, and he decided he was going to go to the media, which he did. It caused, certainly in the region, a firestorm. And to add to the firestorm, he decided he was going to create a website, and he is and continues to publish all of the arbitration documents on this website. Now, I don't know to what extent this media attention affected the Grenadian government's program, but I'm fairly certain it probably didn't help. And I am pretty sure that that was not at the forefront of their minds when they were entering into these agreements. So because we know that we now live in a very media conscious, where information moves very quickly, I anticipate that we're probably going to see this issue becoming more important in the region.
Thank you, Sean. Have a quick sip of coffee, because the next question I'm going to ask you to kick off. So whether confidentiality is a concern or the concern, how is it best addressed from a drafting perspective? So doing your nerdy lawyer thing again, What issues should we be considering when we're picking up the pen or the keyboard?
Yeah, well, I think basic principles apply, which is if it's very important to you, put it in your contract in plain, ordinary language. That's your default. Now, that's the most ideal. Sometimes for various strategic reasons, you may not necessarily want to put confidentiality into your arbitration clause. It may be that you don't have sufficient of a negotiating position to be able to argue for that. And in that case, then you want to ensure that you use a seat and rules that have a position that is consistent with the needs of your particular project. I will say that there are countries that have an implied duty of confidentiality, but you want to be very careful with implied clauses because we all know that if it's not expressly stated, that clever lawyers will always look for a way to try and get around it, and I think that we have to be careful with that. And so what you do is look at the seat, see what the provisions of the seat say, see what the provisions of the relevant institution, and go with that. And I think that's probably a good way. By way of example, I think if we look at this Trinidad case, had the seat been BVI, all of those proceedings and the decision would have been confidential as of right, and they may not necessarily have been in the same position, or certainly someone would have had to have taken a positive action to have that decision disclosed.
Thank you. Nancy, can I ask for your experience, please, on this issue? I mean, is confidentiality actually what the parties always want? I mean, are there instances that you come across where the clause positively provides for something completely different?
I'll deal with the first question, the one, is it something that the parties necessarily want? No, not necessarily. And I agree with everything Sean said. And that is because, and it always been, at least for example, in the US, as from a litigation background, media campaign or PR campaign is important. And you learn, especially when you're involved in some of the bigger cases, how to deal with the media. It's never a good thing to air that you have a dispute as a company or to speak about it, right? Because, for example, in the US, we have ethical obligations with respect to what we can say about ongoing proceedings. However, in reality, this is an issue. Social media is being used to sway public opinion or to even affect Congress and the debates in Congress. So like in big disputes between Microsoft and Apple, you saw some of that use in the media and how that was affecting what was going on with evaluation of how much control Congress should have over the industry. And so a lot of times, if you have a David versus Goliath case, the David may want to be able to talk to the public, garner a lot of support, but also we have to keep in mind that, because Sean, you already covered it so well, you have to keep in mind that in arbitration, the institutions, all of them, will keep the information about the case confidential. Okay, those are in all of the institutional rules. What they don't address is whether or not the proceedings are confidential as between the parties. And they don't have any right, of course, to anyone that is not a party, right? So even though the parties can agree to confidentiality, you also have an instance where third parties in the US can request information about the arbitration, whether or not that is successful. A lot of times it's not, but they do try it. And there are, of course, requirements, legal requirements if you're involved in related proceedings, or if there's a criminal action, just taxes. Most companies in the US, multinationals, if you're registered here, your 10K SEC filings, you have to reveal that you have a dispute. So there's a lot of exceptions to the rule. And there are a lot of ways it can become public, especially when you're doing enforcement, confirmation, or seeking to annul an award. Sometimes it becomes public. So you really I believe in the plain language, but if you're going to deal with it, you have to understand that there are lots of exceptions to a blanket rule and take measures. So for example, one of them is require that if you're going to file any enforcement proceeding, you seal the proceedings, which may or may not be successful, depending on the state you're in. So I'll stop there.
Oh, thank you. That's really interesting. Shai, can I ask for your take on this and on the balance between transparency and privacy?
You're muted, Shai.
Thank you. I'll do that every time I speak now. So it's going to be my tag.
Get more attention.
So I'm taking a slightly different approach to this question, away from what the parties want or don't want, but again, looking at the institutional view or perhaps the public interest view on whether there are cases where transparency is considered generally to be more important than privacy or confidentiality. And I'm going to briefly look at one example where the answer is yes, and one example when the answer is no. And the obvious yes is in the context of investment treaty arbitration. As I mentioned earlier on, ICSID has been publishing awards for a very long time, and in 2014, the UN took action and decided even to pass a General Assembly resolution and open a convention on the transparency of international investment arbitration. And under that convention, which adopts the UNCITRAL rules on transparency in investor treaty arbitration, the presumption, the strong presumption is everything is open to the public. And that includes Article 2, Article 2, commencement of the arbitration proceedings, so the parties, Article 3, publication of documents, so pleadings and evidence in the proceedings, submissions by a third person is Article 4, submission by a non-disputing party, so public interest parties, Article 5, Article 6, the hearings can be open to the public, and where that has happened, they have suffered from a dearth of lack of interest in them, and so nobody turns up in the end, but they can be open to the public. And only at Article 7 does the treaty deal with where confidentiality is retained. And the circumstances where that is retained are very narrow. It's basically confidentiality is retained and upheld where to publish would jeopardize the integrity of the arbitral process. And there are particular requirements as to what would hamper the arbitral process, where publication would, for example, make it more difficult to collect evidence because evidence would perhaps be dissipated, or would make it more difficult for witnesses to appear before a tribunal because perhaps their personal safety would be jeopardized. And so that is in my life a relatively recent development and a very interesting trend towards transparency of arbitral proceedings, which is infecting but has not completed the process. It is infecting commercial arbitration as well, but to a far lesser degree, as I commented earlier. There is no discernible trend towards transparency. On the other end of the spectrum, if I may take another minute, there are new developments in the area which UNCITRAL is also looking at in the area of technology arbitration. Now, a couple of decades ago plus, the WIPO, the World International Intellectual Property Organization, published arbitration rules with very interesting provisions about confidentiality, allowing the tribunal to adopt procedures which protected confidential information, both from the opposing parties and in some circumstances from the tribunal, by appointing, for example, a third-party confidentiality expert who determines for the proceedings whether some information is A, relevant, and B, properly confidential in the sense of a trade secret. Now, UNCITRAL has recognized more recently that this is also an issue for arbitration generally in the technology sphere. So it doesn't have to be an intellectual property issue. And so UNCITRAL committee number 2 is working on a draft set of technology arbitration rules where there will be emphasis on speed, cost, and this time also enhancing confidentiality, very close to or along the lines of the WIPO model. So I've covered both ends of the spectrum there. There are types of arbitration where confidentiality is frowned upon and others where it is seen as a great asset.
Thank you very much. That's really, really interesting. We haven't heard from Maxim so far, so he now gets the floor, and he's got a topic all to himself. So the arbitration process has started, and the parties have decided on the level of transparency, stroke confidentiality that they want. But things aren't running as smoothly as they might. So looking at the various options available, how is confidentiality actually enforced in circumstances where things are going wrong? And what if a problem with confidentiality arises actually after the entire arbitral process is over? I mean, are we done, finished, game over, nothing that can be done? Or is there something that can be done? Maxim, those are just very guideline questions. I'm handing over to you.
Thank you very much, Arabella, and thanks very much to the BVI Arbitration Center for organizing this wonderful event. Arabella, I'll take your questions in the reverse order. I'll first talk about the confidentiality protections that are generally available for the parties arbitrators in arbitration. And then I'll look at the exact ways how these protections can be enforced in practice. I mean, in general, typically in arbitration, protective measures can take one of the 3 forms. You have confidentiality agreements entered into by the parties. You have protective orders issued by arbitral tribunals. And thirdly, unilateral undertakings signed by specific individuals. In practice, you often see a combination of these measures, especially where you have a case involving particularly sensitive information where robust comprehensive confidentiality protections are often warranted. Well, obviously, the best way to ensure confidentiality is by agreement of the parties. Why? For many reasons, but it first and foremost allows you to control the scope, extent, and duration of confidentiality, as well as any exceptions which may apply. And also, crucially, you can also include the remedies and the exact steps that would allow you to enforce these obligations in practice. Now, if no agreement exists when the dispute arose, and that, I think, in part is the premise of your question, Arabella,
Yep.
I think the parties should still try to agree on appropriate confidentiality protections if they can. And often, more likely than not, I think both parties would probably have a strong interest in agreeing on this potentially important matter in arbitration. If they can't reach agreement on confidentiality, or where parties wish to reinforce or enhance the protections that are already in place, tribunal may issue protective order, limiting the disclosure of specific information, setting out how such information is to be shared or exchanged between the parties, and the extent to which that information may or may not be used at the evidentiary hearing. Now, another often additional steps parties may consider is confidentiality undertakings, right? Effectively, they extend confidentiality regime to third parties such as factual witnesses, experts, court reporters, and interpreters by requiring those, say, non-core participants of the process to sign an undertaking to confirm that they would abide with any confidentiality restrictions in arbitration. Now, interestingly, in one case which involved particularly sensitive information, the arbitrator himself was required to sign such an undertaking to guarantee that confidentiality will be preserved in this arbitrator's exchanges in his work with the arbitral tribunal secretary, as well as with other people involved in hearing preparation and drafting of the award. And interestingly, the same undertaking contained a clause providing for arbitrators liability in damages for any breaches of confidentiality obligations. So as we can see, there are a number of tools or measures available to the parties and tribunal to protect confidential information in arbitration. And in practice, we see that they often make good use of such measures. One point I would stress, though, that with any such protections, I think at the outset, you have to be very careful, and the impact any such restrictions are likely to have on the arbitral process, and specifically on the party's ability to present the case effectively at trial. Well, take, for example, attorney's eyes only designation. This confidentiality restriction generally prohibits designated documents from being disclosed to anyone other than the attorneys litigating the matter. Now, what that means in practice is that you won't be able to discuss any such documents with your client, even if these documents include potentially very important evidentiary material. You can't. And you won't be able, obviously, to benefit from any input that the client would otherwise be able to provide on those documents, right? So it's important to think carefully about the sort of confidentiality restrictions that you actually need in arbitration, how to implement those restrictions in practice, and the impact they're going to have on the parties' due process rights. Now, let's assume we have sort of comprehensive, robust, good confidentiality regime we're comfortable with. The question then obviously is, how do you enforce those restrictions if a member of the counsel team, arbitrator, or other participants of the process commit a breach of the relevant restrictions? Well, if a breach of confidentiality has occurred and been properly established, a tribunal or a court, depending on what the appropriate forum is, can issue an injunction against prospective breaches. As far as I'm aware, that remedy is available in all developed arbitral regimes, and one that is quite common in practice when it comes to confidentiality breaches. But the injunction obviously would not address past breaches, right? It cannot do so. There are potentially a number of other remedies that may help with that, at least in theory. You have declaratory relief, actual damages, and in certain cases, you may be able to seek exclusion of materials obtained in breach of confidence as potentially non-admissible evidence in arbitration. Now, it's not clear, in my experience at least, that any of those measures are actually effective in practice in all cases. Indeed, once the horse has bolted the stable, there's generally not much that one can do to address the consequences of the confidentiality breach, or to put the horse back to the stable, if you fancy the analogy. Take actual damages, for example. Even if you are able to establish the source of disclosure, and that obviously is not always straightforward, there often are considerable difficulties in proving the exact loss suffered and the extent of any losses suffered, as well as the relevant causation. So courts and tribunals in practice, instead of granting actual damages, award nominal damages in cases of confidentiality breaches, often in combination with the declaration of breach. One interesting question in this context is whether tribunals may impose penalty for failure to comply with procedural directions with respect to confidentiality restrictions. Now, interestingly, some restrictions like Belgium and the Netherlands expressly allow arbitrators to impose monetary sanctions for failure to comply with procedural directions. It's far from clear, though, whether in practice arbitrators would feel comfortable granting this arguably very draconian remedy to enforce confidentiality restrictions for many reasons, not least because they may not want to be seen as acting impartially to one of the parties, or potentially in breach of their due process guarantees. And certainly it's very rare for arbitrators to impose these sort of sanctions on the parties. So where does all this leave us, right? What can be done to make confidentiality commitments work and ensure that confidentiality regime actually delivers? Well, other than obviously thinking carefully about that important aspect of arbitration from the outset, I think one might consider two steps in particular. One is to include a liquidated damages provision that would expressly provide for penalties in cases of breach of confidentiality. That would or should obviate the need to prove damages if and when the breach occurs. Obviously, as we practitioners will be aware, drafting such a clause may not be easy, may not be enforceable necessarily in all jurisdictions, but I think this is a step certainly worthy a consideration. And the second step I think one should consider is including a provision similar to the kind of provisions we find in non-disclosure agreements, to the effect that any breach of confidentiality commitments, whether contained in the confidentiality agreement or tribunal's procedural order, will cause immediate and irreparable harm to the affected party. Now that, in theory at least, should help obtain more easily an injunctive relief that the party may need to prevent at least prospective breaches of confidentiality.
Can I just ask you a question that you don't know I'm going to ask you? But it's this. The slight impression I'm getting from all of this is that once the horse has bolted, it's not actually that easy to get the horse back into the stable. So do you think the various regimes are strong enough when it comes to a breach of confidentiality, or do you think that parties are perhaps just shrugging their shoulders and thinking, well, I might as well commit a breach because actually the tribunal's pretty powerless and I'm going to get away with it? Do you think this is an area that needs strengthening?
I think it's
sorry, I thought we lost you.
It's
horror of my question.
Yes, no, thank you. That is an excellent question. I think it's a combination of both. I think part of the problem is that parties rarely turn their mind to this potentially very important matter. Often they don't even think about confidentiality as a matter for that has to be dealt with expressly in the agreement. And when they do, they surely do not think about the consequences of committing a breach of confidentiality. But more generally, I think it's not the lack of effective remedies, it's the nature of the breach that probably suggests that objectively there's very little in terms of remedies that can be done to address this sort of breach. Just inherently inherent in the nature of confidentiality breaches, that there's little that can do to address past breaches. But I would say though that the fact that arbitrators can draw adverse inferences and also take into account parties' failure to comply with procedural directions, including with respect to confidentiality, may well be, let's say, an incentive strong enough to prevent parties from at least continuing to act in breach of confidentiality obligations.
Thank you. I've slightly widened the topic there, so I don't know whether any of the other panelists want to add any comments there before we move on to the next subject.
Time permitting, I'll just chime in very briefly to say that there are, in theory, remedies available, but not so much in practice, except for the rare case where disclosure might be of some type of business sensitive information which has a value to it. In all other respects, enforcement becomes impossible because disclosure to the public, at least, is very rarely made by a party, but by its a parent organization or a sister organization. And so the tribunal is immediately lacking in teeth or ability to deal with the offender, and And so it is a very difficult area, and one which, as Maxime said, to use another example, you know, you can't unring the bell. The information is out there, and that's it. And so that's it would require much strengthening before there's an effective remedy.
Yes, and I don't think arbitration suffers in particular. I think the court process has similar issues. I mean, my experience in a case where the outcome of a trial was revealed before the judgment was handed down, with an impact on the relevant one of the parties' share prices. They were summoned before the court to answer how this had happened, and they said, oh, it was some minor marketing person who didn't know what they were doing, who'd been fired that morning. But so what, really? You know, the court was pretty powerless to do anything about it by then. Can we move on to our final topic, which we slightly touched on right at the beginning, which is the potential tension between confidentiality and open justice. Conroy, I'm going to come back to you on that. You know, once the court gets engaged somewhere along the arbitral process, is confidentiality under threat?
Arabella, that's a very good question, because let's just say, having adopted all the prudential measures that Maxim just outlined, you have a tight confidentiality regime, and you are confident, you know, you have confidentiality guaranteed up until the point of an award. Once you get into the courts, it's a very different game. The confidentiality which you have contracted for isn't necessarily going to be upheld or honored by the courts. And that is because, of course, an arbitration and arbitration proceedings, they're creatures of contract. They arise from the arbitration agreement. The parties can agree as between themselves how they wish to conduct their private dispute resolution mechanism, insofar as it doesn't breach public policy. However, when you go to court, it is not a private matter. You are putting yourself at the mercy of the state, an arm of the state, the facilities afforded by taxpayers. And there, the presumption then is very different. The presumption is not that it's confidential. It is potentially that it is open, because, as you rightly say, the judicial system, certainly in England and in all the common law countries we've been talking about, is that of open justice. And it is because openness and transparency is necessary for confidence in the administration of justice, why the courts are really very jealous to guard that. And we saw that during COVID, you know, the courts were very, very keen to ensure that links to virtual hearings were open to the public, that anyone who had time on their hands could wander into a Zoom room if they so wish. So there's a big tension there. The law in the countries, it does recognize, though, the specific demands of arbitration, and they recognize that it's private dispute resolution. And so the law in certain in England makes certain exceptions for this. And so under the civil procedure rules, and specifically CPR 6210, and I'm sure this is the same in perhaps in the Eastern Caribbean, which is modeled on the same procedure. When you have an arbitration claim, that is a claim on the Arbitration Act for set aside, or for challenging the substantive jurisdiction of the tribunal, or in England on a point of law, it says that the court may decide whether the hearing is public or private. And then what it goes on then to do is to try to balance the public policy concerns. So it goes on to say that where the challenge in question is on a point of law, so for example, a preliminary point of law or an appeal on a point of law, which is still possible under English law, then the hearing is likely to be public, because there the court says, and the law says, there is a public interest in understanding what the law is. There is a public interest in seeing how the law is administered, the substantive law in the dispute. However, if all that's at stake is the substantive jurisdiction of the tribunal, so it's not really a point of law of public importance, then it is more likely to be private. So there are these presumptions baked in, which is very interesting. The CPR doesn't just institute a blanket rule, but it tries to make a distinction between in what circumstances does the court have and the state have a legitimate interest in transparency? And when might it be said that they really don't have a legitimate interest because it's about the minutiae of the dispute between the parties? So we see that presently, but the mood music is changing a little bit. And one thing that I was very struck by is a recent decision of the Court of Appeal in England in Manchester City Football versus Football Association, is a case which had to do with the footballers in England, some controversy with the football clubs. And it went to arbitration. The question of disclosure of documents went to arbitration. And there was a challenge to the substantive jurisdiction of the tribunal and to certain parts of the award. And both parties made submissions asking for the fact of the award, the judgment, to be private. And the court rejected it. The court said, no, I don't see, the judge said, that there is any potential for disclosure of significant confidential information in my judgment. And therefore, the requirement of open justice trumps the parties, although unanimous preference for confidentiality. And that was then appealed to the Court of Appeal and upheld. So what we see is it's not even a question about whether there is agreement as between the parties. The courts have made it clear that it is for the court to judge what the balance is between the public interest and the party's legitimate interest in privacy. And another thing that I think is indicative of the mood music is, as you may know, the Arbitration Act and regime in the UK is presently under revision or in consideration for revision. And what has been very striking for practitioners, including myself, is the very cavalier way the Law Commission seems to have treated confidentiality. They say up front, we don't think that there should be a presumption that all arbitration is confidential. And they've actually said they don't think that there should be a codification of confidentiality in the Arbitration Act. So, seeing what the courts are doing in their specific decisions, seeing the mood music from the Law Commission, and seeing the bigger trends that Shai outlined in relation to investment treaty arbitration and how they're trickling in and creating a different mood and a different perspective in commercial arbitration. I think the courts are definitely a big loophole for confidentiality. If you want the assistance of the court, there is a big chance that you're going to have have certain aspects of the award and the proceedings in a public judgment. Now, this is not to say that the courts will not uphold confidentiality, but the bar is definitely higher, certainly where there is a substantive issue of law or a point of public importance that is likely engaged in your arbitration.
Interesting. Nancy, can I ask you then? I mean, are the US courts as cavalier with the parties' wishes for confidentiality, and is there any different sort of mood music over with you?
Thank you for that. I really appreciate Conway's comments. We have a similar thing in the US, a similar approach. So if you look at during the arbitration or pre-award phase, we have had cases in the US, some in New York, where the courts have refused to enforce a confidentiality agreement if they find that it's overbroad, for example, or it's unconscionable, or it gives one party unfair advantage. So in some of those cases, domestic cases, unconscionable, for example, a lot of these cases of sexual harassment that are arbitrated and then the requirements is that the award or whatever is confidential forever, or their agreements, or if it's too one-sided, for example, the duty of confidentiality, or you'll have employers that have repeated arbitrations with employees on the same issues, but the employer has access to all of that record and knowledge, and the employee doesn't. So I think in the US, you'll see, especially in domestic cases, the courts being a little bit more proactive and really analyzing who benefits from this confidentiality agreement. Because generally the courts will uphold confidentiality agreements except under these circumstances. Now, when you have the award, of course, the minute you go to court, the same issues that Conway talked about are important and followed in the US. You can, if the parties agree to keep the award confidential, you can try to file, as I was mentioning earlier, your arbitration in court that the documents are sealed. However, to my surprise, I found the same thing that Conway described. In arbitration, if the two parties agree, for the most part, the arbitrators will try to accommodate them, but not in the court of law. So even though the parties agree to keep the award sealed, the courts will review whether that's needed. And if so, is there a trade secret? Is there some type of sensitive information? Because generally what I've been reading is that, because I don't mostly go to court, so this was really interesting for me. What I've been reading is that the courts will evaluate, is there a need for it? Because they're not friendly towards sealing records in court to begin with. So there needs to be a good reason. There needs to be an overriding reason for them to keep it confidential. And there was even one case where there was a mandatory injunction in that award, and the court decided not to seal the proceedings, the documents, because it felt that injunctions are a matter of public interest. So I find it's very comparable to what Conway excellently described in the US, I think.
Thank you. So Sean, turning to the courts of the Eastern Caribbean, do they just take over and ignore the parties' wishes? Does the BVI fall in line with everywhere else, or is there a spark of hope?
Yeah, no, I at first I want to say that I'm somewhat disappointed, because when Conway started talking about football, I thought we were going to up our sexy quota by talking about the juicy bits, but in the spirit of confidentiality,
Exactly.
you left all the good bits. I was waiting like, ooh, what were the bits that they didn't want us to know? But I think BVI, in terms of principles, are exactly the same. Our legislation says that if there is legal or public interest in an arbitration court-related matters, that these can be open to the public or disclosed. But I think our starting position is different. So whereas in the UK, you start with the principle that everything is open, and then you have to give a reason why it should be made confidential. In the BVI, we start off with arbitration proceedings are confidential, and then the parties can make applications, or whether it be the parties themselves or third parties, to have the proceedings either in open courts and or to have the decision published. And even with the publishing of the decision, parties can agree, or the court can publish the decision but redact portions of it which are sensitive. And I think we tend to take that approach because BVI wants to attract arbitrations. We want to be a jurisdiction where persons want to bring their international disputes, and because this is a sentence, we want to ensure that we're giving people the most protection as possible. So I think it's fair to say that we are more on the stricter side of enforcing confidentiality to the extent that one can, given all the conversations that we've had about it here.
Thank you. So this webinar has been so sexy that we've nearly, in fact, overrun. We do have a few moments left for questions, if there are any. I can't actually see, because being the vain person I am, I'm not wearing my glasses, whether there are any questions on screen or not. So I'm going to leave Sean, who is wearing her glasses, to see whether there are.
Yes, well, we have Chantel, our legal assistant, who has been monitoring the Q&A section. Are there any questions, Chantel?
So I believe this was touched on before, but I'll still ask the question in case there's anything more to add. And it is, what happens when court action commences which overlaps with the subject matter of the arbitration? What extent are those cases open to the public and the resulting judgment published?
I don't know which jurisdiction that is addressed to. So, I mean, Conway, since you were the first to start with the actual topic, do you want to take that one? I think we've probably pretty much covered it.
Yeah, I mean, there seems to be two scenarios there, right? There is one where it's related subject matter, perhaps a litigation that started, which is trying to circumvent the effect of the arbitration agreement, in which case I suspect that one of the parties may want to seek an anti-suit injunction to stop that, if that's what's happening. But there is the second bit where it could be that there's an arbitration going on, but they need the assistance of the court. In that instance, then it is likely that there will be the sort of disclosure that we just spoke about.
Yeah, and Kwame, I think that raises an interesting point, certainly from a BVI perspective, because of course, if you start court proceedings, but as if the arbitration clause does not exist, then for the provision of the legislation, does that constitute an arbitration? And then once I make my application for an injunction, at what point does it become arbitration related proceedings? Because of course the legislation speaks to arbitration related proceedings. And of course, if there were not these gray areas, we lawyers would not, be able to exist. So we're grateful for it, not grateful for it, but I think that is an area that would cause some tension.
I would just add that for parties who do care about confidentiality, this is an area where the arbitrators can actually give an effective remedy. And one of the reasons for arbitrators giving the anti-court suit injunction would be confidentiality. So that is a ground for seeking it in the first place, other than the simple breach of contract and promise to arbitrate. But the power to injunct a party from continuing court proceedings commenced and breached is strengthened by the breach of the confidentiality as well.
Yeah, that's an excellent point.
Yes.
Chantal, is there anything else?
There's another question, but I believe Maxim covered this, and it's how should parties handle a request for document production when the issue of confidentiality is at stake?
As a general matter, we do know that it's a recognized ground under the IBA rules for taking of evidence, and generally in arbitration practice that the parties may object to the production of their own documents on the basis of confidentiality. Perhaps what this question is aiming at, what do we do when there are serious concerns as to how meritorious these objections are, whether they are driven by genuine confidentiality concerns or rather unwillingness of the party to provide the materials because those would be unhelpful to that party's case. There are a number of things one can do. If the documents are very, very sensitive, then it's possible that an arbitrator or the tribunal will have the right to review these documents and then decide whether or not these confidentiality concerns are justified, and if so, what steps need to be taken in terms of production, etc. If the documents are so confidential that even arbitrators cannot look at them, it's possible to engage a third party with tribunal's approval to review these documents, and then that party will opine on, again, the nature of these materials and the extent to which confidentiality concerns are actually justified. I mean, it's quite difficult to answer this question in abstract, but in general, I think these are the steps one would normally take in this sort of scenario.
Well, thank you, Maxim. I think that probably brings us to a close. I don't know whether it's my job or Sean's to thank the amazing panel for putting up with my horrible questions and answering them as well as they have. So on the basis that it's my job to say thank you, I say thank you very much indeed, and thank you to everyone who has joined us today.
Yes, and I will echo Arabella's thanks and remind everyone that there will be other events, and if you want to be notified, please subscribe on our website to our mailing list so that you will have notice of the next sessions. Our next one will be a ADR clinics in Barbados. So if you are in Barbados, we will be doing a arbitration clause and document production session in conjunction with the University of the West Indies. So again, email us if you're interested, and we'll add you to our list. Thank you very much.
Goodbye, everyone.
Thank you.
Thank you so much.
Thanks very much, everyone.
Yes.